ಇದರಲ್ಲಿ ಒಂದು ನೋಡಿದೀವಿ, ಅದು KPSC KPSC ಪರವಾಗಿ ಪ್ರಕಾಶ್ ಅಪೇರ್ ಆಗಿದ್ರು. ಅಪ್ಲಿಕೆಂಟ್ಸ್ ಪರವಾಗಿ ಭಾಗವತ್ ಅವರ ಆನರಬಲ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೆಡೆಡ್ ಬೈ ಆನರಬಲ್ ಜಸ್ಟಿಸ್ ದೀಕ್ಷಿತ್ ಸಾಹೇಬರು, ಅವಧಾರ್ ಸಾಹೇಬರು. ಅದು ಇದೆ that matter covered with that was OMR AW examination. The rule what RDPR. Okay, that is it.
They are not coming.
It is not. It is something of a date that I appeared for. That has nothing to do. That is you to like notice that. It made it as like very things. Cash has got to be there. I was not seeing. 285 to 398 and 686 to 689. ನಿಮ್ದು ಅದರಲ್ಲಿ ಇವ್ರದ್ದು 563 ಪ್ರತೀಶ್ ಅವರು. ಎಲ್ಲ ಕೇಸ್ನಲ್ಲೂ ಈಗ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ KPSC ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡಿ. ಹೌದಾ, ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡ್ಬೇಕು. ನಿಮ್ ಸಪರೇಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಸರ್. ಫಿನಿಶ್ ಮಾಡಿದರೆ ಒನ್ಸ್ ಫಾರ್ ಆಲ್ ಅವ್ರ ರಿಪ್ಲೈ ಕೊಡ್ಲಿಕ್ಕೆ 563 ಅಲ್ಲ ನಿಮ್ದು 686 ತಗೊಳ್ಳಿ.
The controversy revolves around whether the examination procedure that is adopted is fair. But certain baseline arguments is that this is not an adversarial litigation, as in a transfer or in a seniority somebody's name. It is not an adversarial litigation. Ultimately, the arguments before your lordship are all pointed towards whether all the candidates had an equal opportunity. That under Article 16, all of us have an equal opportunity to secure an employment. And any action taken towards employment, did all of us have an equal opportunity to contest or participate in the same selection process? Ultimately, your lordships are being asked to decide that the entire recruitment, in my respectful submission, is governed by the rules known as the Karnataka Civil Service Direct Recruitment General Rules 21. Like it is under these rules, under Rule 6(1)(b), that a mandate is set that while recruitment to the posts of Group A and B, the question papers shall be set in both Kannada and English.
You have quotes, you have given that rule?
Yeah, the book is and just read it for your lordship, then it's available in this book. ultimately I don't think it is disputed. Examinations will have to be said both in Kannada and English. But I will not repeat the argument made by the learned Murthy. He has placed the memo. But the facts undisputedly would reveal that when the examination was conducted for the first time, there were certain discrepancies in the translation, and therefore it was cancelled, and therefore the second examination was called. Now, the second undisputed question before your lordship is that there is in fact an approach, there is in fact discrepancy in the question paper in the English and the Kannada language. In the preliminary examination that is being conducted, there in fact is discrepancy. Now, I don't think that is disputed even in the statement of objections. I will not trouble your lordship with my application. Even if your lordship, my case before your lordship, even if your lordship were to reject my pleadings, solely on the basis of the averments made in the reply statement, I am entitled to succeed in application. Now, my lords, admitted cases that there were discrepancies. Now, therefore, KPSC Malad would refer the matter to an expert committee. And in the reply statement, Malad, they would say that an expert committee which is constituted, about 12 expert committees are constituted. Internal page 3, paragraph B. 12 subject expert committees, and each committee consists of 3 subject experts. In the reply statement, I'll refer only to the statement of objection. It is their case that the subject expert reply statement internal page 3.
reply statement ಬೇರೆ ಕೇಸ್
ಇದರಲ್ಲೂ ಹಾಕಿದ್ದಾರೆ ಯಾರು
ಕಾಮನ್ ಆಗಿ ಹಾಕಿರಬೇಕು
563.
Internal page 3, para B. Right, in the middle of the paragraph, 12 subject expert committees, and each committee consists of 3 subject experts having teaching knowledge of both languages, Kannada and English. The expert committees having examined the answer keys has opined that in respect of 5 number of questions, the translation to Kannada language and also the technical aspect would so impact a candidate that it would not be possible to answer the question correctly. It was recommended by the expert committee that in respect of these 5 questions, grace marks must be awarded to all candidates. But this is all that I am saying. Therefore, my admitted case before your lordship was that when originally the second exam was held, that there were in fact discrepancies in the question papers, in the questions in English and Kannada language. And therefore, Malad, this expert committee, 12 expert committees, came to a conclusion, Malad, that these 5 questions require grace marks and they should be awarded to candidates. Now, Malad, these are undisputed facts. The last undisputed fact before your lordship is that when the exam was held, it was a single OMR. Now, Malad, there is no different OMR for students answering in Kannada and student answering in English. Therefore, Malad, today it can't be differentiated that this person has answered in Kannada and this person has answered in English. We don't know which candidate has looked into what question and has answered what. It's a common entrance exam, Malad, for all of us. Now, Malad, what happened after the exam was, they published a provisional key answer and call for objection. Malad, we filed our objection. On filing of the objection, KPSC in the statement of objections to take a stand that we referred these things to the expert committee. So, admitted cases that when the objections were sought and when we filed our objections, these objections were never placed before the paper setters. The person who framed the paper, it never went back to him.
Does it go? I don't think so.
Yes.
It goes
Yes, it does. It does. I'll tell you Lordship first.
because
I'll
the
demonstrate.
questions are collected from various sources.
Correct. There's one question paper. Ultimately, there's a question paper setter one person who would finalize these questions. I'll come to the aspect of translation also. But I'll point out some judgments. The generally accepted principle is it is the question paper setter, Malad, who will bring the key answers. Because these are examinations where technical aspects are also involved. And the questions are framed, Malad, in the perspective of the question paper setter. There may be multiple choice question answers. Therefore, the answers that he would give is from the perspective of the question paper setter and not from a third person's perspective. So the answer being subjective, the original key answer is always set by the paper setter, including in KPSC.
This is a multiple choice question.
Yes.
So where is the subjectivity in that? They are objective type.
Yeah, I'm just giving an example.
If it was a essay type, then I agree.
Yes.
But it is a multiple choice question which is very, very clear. Either A will be correct or B will be correct.
Correct. But would you like to just, I'm not troubling. One of the questions, Malad, where discrepancy was pointed out was whether in the Constitution 6th Amendment what was done. Malad, multiple choice questions are available. According to the paper setter, it is one answer. According to the learned AIG, Malad, it may be both A and B. To me, it is C. Now, Malad, therefore, always, including in KPSC, it is the paper setter who sets the key questions, key answers. Now, when discrepancies arose, it went back, Malad, to an expert committee. Now, who constitutes this expert committee, we don't know. It is a non-transparent process. Even before your Lordships, along with the reply, we don't know who these experts are, who constituted them, when they were constituted. And more importantly, what is conspicuous by its absence in the reply statement is whether the objections of all these candidates insofar as the translation and the questions were placed before the expert committee is not revealed, at least to me, in the reply statement. So they say that it is in respect of 5 questions that we decided to award grace marks. Now, which of those 5 questions also I don't know. Now, let me just read that statement again where KPSC says that expert committee decided to award grace marks of 5 to all the candidates. That one sentence is sufficient to demolish, Malad, the case of the KPSC. Now, irrespective of whether the students have attempted the question or not, if the grace mark, Malad, going by the statement, and I'll read it again, it was recommended by the expert committee that in respect of these 5 questions, grace marks be awarded to all candidates. Internal page 3, para B. I'm hoping, Malad, that they will not recite from the statement. Now, grace marks, Malad, was awarded to all candidates, irrespective of whether they have attempted the question or not. Now, Malad,
How can you find out who has given, who has not given in 1 lakh candidates?
But that's what they said. We have given it to all candidates.
That depends who has attempted that question.
But your marksheets are not.
I just want to know this. You are making a very sweeping statement.
No, they have said
See,
that.
Kripant will only get to the person who has attempted that question.
But I would be so grateful if it is demonstrated by way of documents before your lordships. But may I read the statement?
Very simply, they have mentioned that grace marks will
For
be
this
awarded to all candidates.
Candidates. That's exactly what I'm stressing upon. It can't be to all candidates.
Kripant will be only for these issues.
Illa.
Last statement paragraph.
5 marks in so far as 5 questions. Grace marks is awarded to every single candidate.
It was recommended by the expert committee that in respect of these 5 questions, grace marks be awarded to all candidates.
That's right.
It
It is not to candidates. They have not said grace marks was awarded to candidates who had attempted those 5 questions.
the attempt to give to a
Because see, grace mark as per if you see this, fee to order anyway, where they are, ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಪ್ರಕಟಣೆ ಬಗ್ಗೆ ಏನಿದೆ ಅದರಲ್ಲಿ Kripant is only for 4 questions and another
And let me go by this one. Grace marks is awarded to 1 question. We forget 5. We are not on numbers. We are more importantly on the question, Manoj, as to how these grace marks were awarded. This is something that they have made in their statement of objections. So, insofar as grace marks is concerned, may I just rely upon Manoj's 2 judgments this passing. This was in a case of CBC, Manoj. Well, would your lordship straight away come to correct? This was also a case where, insofar as the key answers were given and the questions were so vague that it could not be comprehended by students writing the exam. Correct, well, I first tell the reasoning and read the judgment. The reasoning is that it's a multiple choice question answer and there is negative marking. So there is a student, Manoj, who takes a calculated chance and says that I will mark answer B as the correct answer. I will take the chance and I will risk a negative mark of 1/4 mark for the question. And there's another candidate who said, I don't want a negative mark at all, therefore I will not attempt it. Now, Manoj, and candidate who was attempted and a candidate who was not attempted are treated equally, Manoj, when ultimately subject experts, so-called subject experts decide, saying that everybody is to be given. That was found fault, Manoj, at paragraph 12. I'm just reading only the relevant portion. There is yet another problem, namely that of 7 questions which are so vague that they are incapable of having a correct answer. The appellate university, in respect of those 7 questions, has given the credit to all the students who had participated in the entrance test, irrespective of whether someone had answered the question or not. We do not think that this is the proper course to follow. It is only unjust to give marks to a student who did not even attempt to answer those questions. This course would mean that a student who did not answer, say, all the 7 questions would still get 28 marks, each correct answer having 4 marks. The reasonable procedure to be followed, in our opinion, would be to give credit only to those who attempted the said question or some of them. Having regard to the circumstance of the case, we direct that for the students who attempted those questions or some of those questions insofar as they are concerned, the said question should not be treated to be part of the question paper. To illustrate, if the student answered all the 7 vague questions insofar as the student is concerned, total marks would be counted as so and so, and like this. The 7 vague questions in paragraph are question number 4 and so on and so forth. 13 minutes. In view of the aforesaid, we modify the direction contained in the input judgment of the High Court direct appellate university to re-evaluate the answer book in terms of the aforesaid direction, and on that basis, prepare the ranking of the students within 2 days, so on and so forth. But this was the first judgment in my respectful submission, where they found fault with en masse award of grace marks. But the other judgment, which I'm certain my learned friend will also rely upon, I will rely upon that also. Exact fact situation. I will also rely upon the portions which are helpful to me, which would go against me and then distinguish me. But this was a case of NEET undergraduate examination. In NEET undergraduate exam, in all the states, exam is conducted both in English as well as the local vernacular language. Here, the examination was conducted in English as well as in Tamil language. In the Tamil language, at the time of translation, there appeared to be a discrepancy. Would your lordships come to paragraph 12? Paragraph 12, they notice the question, and paragraph 14, how? Now, may I just draw your lordship's attention to para 16? I have not yet made this argument, but since it is available, that would be my next list. Since it is available before your lordship, let me just read that. The translation will be done from the target language to the source language and back to the target language. Please see the words that are employed. The translation will be done from the target language to the source and back to the target language. Thus, for example, a question in English translated in Tamil will be translated back to English. This dual translation approach will remove any chance of ambiguity in the question paper. In spite of the safeguard, it is proposed that in case of any ambiguity between regional language and English language, it will be English version which will be final as held by this court in the order dated 25/1/2018 referred above. This is the portion which my learned friend will refer. Now, kindly come to paragraph 18. Assuming that there was some justification in the plea that the students were prevented from understanding the question and therefore could not answer properly, we find it difficult to sustain the remedy provided by the High Court. The number of students that had appeared in NEET UG 2018 was 13,23,676. Approximately 10.5 lakh took it in English, approximately 1.5 lakh opted for regional language. And of these, nearly 24 candidates took the examination in Tamil language. Because mistake in translation which could have been detected and avoided by the students, we find it unjust that all students across the board who took the examination in Tamil have been awarded 4 marks for all the 49 questions without any reference to the answer to those questions. The consequence is equally unjust and unacceptable as the students who gave the examination in Tamil have been unduly benefited only because they opted to give examination in Tamil. It is said that there are some students who might have otherwise failed, but for the addition of marks by the High Court. Most of these students have scored higher than those who gave the examination in English and other regional languages. This is mainly due to the blind allocation of 196 marks to every student who gave exam in Tamil. In Guru Nanak Dev University versus Soumya, in similar circumstances, whereafter CBSE opined that 10 out of 21 key answers were incorrect, this court called for a report from CBSE and Delhi University as regards correctness of those 10 answers. And thereupon, in order to preserve merit, the court directed the university to re-evaluate the answers to the aforesaid 8 questions with reference to the answer. This court adopted by this court was to prevent arbitrariness in awarding marks. We see no attempt in the interim judgment to have the marks evaluated by an independent. Instead, the High Court resorted to blind allocation of full marks of for each of the questions. Now kindly come to paragraph 25. Ultimately, Maharaj, there was a direction, Maharaj, to redo the test. Therefore, Maharaj, my submission to your Lordship says, this blind allocation of grace marks to all candidates here, irrespective of whether they have attempted the question or not, Maharaj, is incorrect procedure that is being followed. Your Lordship,
Have you pleaded this in your?
Maharaj, I did not even know until they came to my request statement.
You only are asking for re-examination on certain
That's
ground.
That's right.
But you have not made this as a
Maharaj, that was not even.
that we have been given unfair marks. When that did.
Maharaj, that was a fact subsequent to the filing of the application. When the application was filed, it was not a fact which was available.
Challenging in your application the incorrect translation.
Maharaj, that's right. I'm coming to that question also. That's one. But please see the
Tell us
reply
one
statement.
thing. When you filed this application, that was this 3-2 notification was out.
Maharaj, I'm sorry.
3-2 notification that this is a correct answer, that is a grace mark was out. And you have filed your application on 10-2. There is no pleading on this that I will be unfairly marked.
Maharaj, when was the final key answer released?
3-2, 10-2.
Maharaj, no. The first application that your Lordships are holding, the first of those applications was filed much before that. What was argued in the first application was filed much before that.
No, but I
It was not
said this 3-2 was available to you.
Maharaj, yes.
But you have
and-
not pleaded that Kripan should not be
No,
given.
but I did not know if grace marks was awarded to all candidates or not.
But that time you have application filed, the final marks were also out. Final.
No, they did not say grace mark was awarded to everybody. Maharaj, and may I just say this, Maharaj, if your Lordship will not mistake me. In the common reply. That's the common reply, common argument, Maharaj. I am instructed to tell. Grace marks is awarded, Maharaj, if the key answers are wrong and not to any of the translation. If there is any error in translation, Maharaj, I am not troubling the Lordships again with the errors in translation. It was pointed out yesterday. Compendium is given with the errors in translation. So, Maharaj, I am not going back to that, Maharaj, pointing out each of the questions and saying that, look here, this is the error. This is what ought to be considered. And Maharaj, yesterday, Maharaj, please don't mistake me for saying that. Yesterday, when we insisted, Maharaj, that state government takes a stand, it is because of this. We are literally groping in the dark. We don't know what KPSC has considered. We don't know if our objections that we have filed is in fact considered. All that I know is 5 grace marks are awarded. Is it for wrong questions? Is it for wrong key answer? Is it for any other reason? I don't know. It's an absolutely non-transparent process that is being held before your Lordships. My instructions are that grace marks is not awarded to the errors in translation. It is only in so far as the factual errors in the key answers that are concerned.
That is the end result. Because the translation was not correctly done, the applicants or the people who are taking exam could not understand the question.
Yes.
That is the key. See, what is the purpose of an examination? The purpose was that the person should be able to understand the question and write the correct answer.
I just do
So
one
I'm
thing.
just asking you. Because what is the end
result?
result anyway? End result is that you should be able to understand the question and mark correctly.
Correct.
So whether they did it for the key answer or the key answer was on the translation is immaterial. The end result anything. End result is that you should be able to comprehend the question and should be able to answer. Considered by an expert committee. Key answer they have said this is one. And they have also said that experts were there both English and Kannada. I don't think so that you should be harp upon this that whether our translation problem was taken care of not. Because end result anyway, What are you saying? That I could not understand, that's why I could not mark the correct answer.
May I put it this way? I just put it this way, another perspective again. That the object of examination in a selection process is all of us are given a fair chance.
To exclude,
Right?
to exclude.
To exclude.
There are only
Absolutely.
384 posts.
Fair chance for exclusion. No, my lord, it's not a case where by some means we are excluding. That is not there. So it's by a fair chance. Now the second thing that your lordship pointed out was ultimately the end result is they are considered. That's what your lordship there are presupposing is that my objection was in fact considered to these questions. Your lordships are
No,
presupposing.
we are not presupposing. We are asking you to clarify.
I'm saying
Your pleading doesn't talk at all about the grace
my
mark.
pleading.
Though 3, it has already been done. Third, it has already been done.
Well, let's kindly have a look at the final key answer. I don't know if grace marks is awarded to everybody. When that statement was made before your lordship, I'm pointing it out.
You could have filed a rejoinder.
Well, rejoinder, nenne the state government to it Badra Niltara Anta. Because of this.
See,
Well,
state government,
Can-
1 minute, they are the selection authority. KPSC is a constitutional body who has been given that. There is a big rule, act, everything is there for adequate.
Right.
There is a big rule, KPSC has their own rules, government rules are there. So, government stand is important, not important, that is a separate issue. More important is that how KPSC has done their work.
And it's exactly what I'm pointing out. And today, what is being pointed back to me is that this is not a pleading. Well, these are admitted things. And your lordship will not rely upon my. Well, it's kindly. This is a legal position which I don't think I'll agitate before. And admitted pleading. I'm not, I can understand if it's a disputed pleading, your lordship will ask me for a rejoinder. I am admitting to the pleading. It's an admitted pleading. It's a document which is available before your lordships. And now, if I'm making a legal submission, I don't think your lordships will send me out of the court by saying that this is not a pleading. It is a document which is placed before your lordships. It's a pleading made in the reply statement which is admitted. And what is blatantly illegal, cannot, only because I say it is not a part of my pleadings, cannot be sent out. Yes, and this.
See, when the results were out.
Yes.
The results were out twice,
Yes.
twice or one time?
First time and then it was cancelled and therefore this.
No, that
Provisional
re-exam,
advice.
no, not re-exam.
Provisional.
No, re-exam is a separate.
Yes.
Now, when they got the marks,
Yes.
they must have also got the grace marks, no? For all the questions.
That's the problem. That's exactly what I'm pointing out. I attempted those questions and by chance it is a correct. Therefore, my marks remains at 35. Now, my Shami did not answer any of those questions. He got grace marks because of which now he is an entrance to the final exam. Had he not been granted those grace marks, Shami would never have stepped into the final examination and it is me who would be sitting there. That is the case before your lordships.
Not period at all.
Well, it's an admitted pleading. I have placed the final key answer before your lordship. Of course, I'll leave it for your lordship's consideration. But that's a legal position, which I have placed for your lordship's consideration. Now, the other main issue insofar as translations, we have figured out what the errors are. With the limited document and with the reply statement, I say, my objections are not considered. Now, before this, I took your lordship to the 2019 judgment, that is Rangarajan's judgment. In 2019, what the Supreme Court in Rangarajan said?
The question papers are having both English and Kannada simultaneously.
Yes. Well, I'll come to that. There,
It's not that English is separate and Kannada is separate.
same question. In 2019, of course, in Sankalp education in 2018, But the method that was set up to follow for this vernacular translation is at page para 16. That's what I refer to. If the exam is being conducted in English and being translated to a vernacular language, we frame the question in English, then go back to Kannada. We translate it to Kannada. And from Kannada, we translate it back to English to see if the Kannada question has the exact same meaning as in English. Now, that is the procedure that has to be followed for framing of questions at the time of a competitive examination. But I can only say that when we have, as your Lordship pointed out, when our pleading was so much on when the pleading was so much on translation, I am not yesterday my learner friend took objection to what Mr. Ragopal said, they don't have to advise us. I'm just pointing out. Please see the reply statement. If they had said that this is the method that we have adopted for translation, I had possibly no case. I don't know what they have done, but I can tell you actually from the reply that they have not done this. If this was the method that they had adopted, where we frame the questions in English, whether framing of question in English is the correct procedure, I'll just come to that. But assuming what appears to have happened is a Google translation, a chat GPT translation. English ಹಾಕಿದ್ರು ಅದು translate ಮಾಡಕ್ ಹೋದ್ರು ಅದು ಕನ್ನಡದೇನೋ ಬಂತು. Now, had it been translated back to the source question, then perhaps they would have identified this. Therefore, what your Lordship will also notice today is the error in the examination is not disputed. What is disputed before your Lordships is the number. Is 1, 5, 10, 20, 79. So the error in translation is admitted.
Asking for the first time for KPSC like this?
Yes. In so far as translation, controversy to
exam is happening since more than 50 years.
That's what I was saying. Controversy to KPSC is not clear. But this controversy to KPSC, in my respect, submission is new. This translation subject to what?
Because of chat GPT on both sides?
I don't know.
On both sides. You have also taken help of Google Translation. You have written near the question Google.
I have the compendium.
No, compendium illa. They have written somewhere Google Translation.
That is just to point out that forget the expert translator. Even Google Translate will show that the translation is wrong. That's what that is being pointed out. We don't need to go to an expert. Even Google Maps sitting in US will say that the translation from English to Kannada is wrong. And certain minutes, my learned friend will rely upon second half of Peter Rangarajan's judgment, right? Where they said that when you paragraph 16 bottom minutes, they define the methodology for translation. And then they say, assuming there is still discrepancy you will rely upon the English question. Now, that is one of the conditions, Manoj, really answer key is what they say in the question paper. Just have a look at para 17. We find that this last mentioned clause is extremely significant to ensure that students have some basic knowledge of English even if they are allowed the facility to write the examination in their regional language. Presumably, this is because the entire education of MBBS and BDS course throughout the country is taught in English. Now, kindly mark this distinction. To rely upon that portion is one thing. To oust my case is one thing. But to say, Manoj, in that fraction matrix, Supreme Court said, for example, engineering is conducted only in English throughout the country. Therefore, to say, Manoj, that Hindi will prevail or Tamil will prevail over English might be different because all students are studied in English. Unlike Manoj, where people from every part, every walk, every language, we have Kannada medium students, Manoj, who are writing the exam. And for them to say that you will understand what is in English and forget what is in Kannada.
But was it in the question paper?
Yes, that is what is being referred to. This,
In this case,
yes,
this is the NEET exam, I think.
yes,
In this KPSC, do they write this?
yes, Manoj, it is written in the question paper booklet. Because they are heavily relying upon it even in the booklet statement. But then I can point out from the questions, Manoj, how. Just have a look at page 200 of my application.
I want to know how difficult it was to understand. Was
I
it
tell you
not-
that. I tell you that.
The
That's what-
first one, because I saw one or two. This is Tyag and Bali, I mean, sacrifice, which word they have said Bali Rebecco and Tyag, they have written the word Tyag. Now, there are many words which have many meanings. One word they have, I was just going to one or two questions. This was about somewhere.
Construction sentence based on the meaningful.
No, there should be only many. Buffalo question it too, I just saw. ಅದರಲ್ಲಿ ತ್ಯಾಗ ಮಾಡಿದೆ ತ್ಯಾಗ and ಬಲಿ ಜ್ಯುವೆಲರ್ ಸಿಂಗ್ ಬಲಿ ಇರಬೇಕು ತ್ಯಾಗ ಬೇಡ ಬಟ್ ತ್ಯಾಗ ಮೇ ಬಿ ಆಲ್ಸೋ ದೇರ್ ಸ್ಯಾಕ್ರಿಫೈಸ್ ಮೀನ್ಸ್ ತ್ಯಾಗ only. It's also this is
Can I'll just ask my colleague.
yeah, I just want to know because your entire case hinges on that poor translation. So I just want to know
Yes.
how difficult it was to understand.
Yes.
That you all are aggrieved and you are saying that you have prevented from answering. How
Very-
difficult it is.
Very well. I will straight away answer that. Would your lordship just have page 200 of my application, clause 7. I will read this and point out the question. Page 200 of my application in 686.
Yes, 74.
Clause 7, question paper book, 200. Well, I should got the first, see the question paper. Not, that's the,
400 million.
clause 7 of the first facing sheet of the question application or 686.
Subject code 590 ಅದನ್ನ
Subject code 5. Well, actually,
Annexure A22.
yes. Right, I'm just going one step further. Can I read that clause? Questions are printed both in Kannada and English. If there are any confusion in translation of Kannada question, candidates will refer the question in English and understand the question. Now, if there is any confusion, Kannada personal yenar gondala idare, English ಹೋಗ್ಬೇಕು. ಕನ್ನಡದ ಪ್ರಶ್ನೆನೇ ಬೇರೆ ಐತಿ, ಇಂಗ್ಲಿಷ್ ಪ್ರಶ್ನೆನೇ ಬೇರೆ ಇದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ. The case that I am pitching before your lordships today is the question in Kannada is entirely different than what is in Kannada or English. If the answer in English is C, the answer in Kannada is B. No, my lords, key answers are one. They refer to English and say C is the answer, but in Kannada it is in fact B which is the answer. Please have a look at 31. This is exactly what your lordships asked me. Just have a look at question number 31, which is before your lordships at page number. Compilation and legal vision. Can I just refer to it? Compilation alle ide. Council gave. I just read it out for your lordship. Yesterday it was read out
Memo.
along with the memo.
Along with the memo. Ali on the put it to. Thank you.
Question number 31. First page alle. In that compilation, just the first page. First page is the question number 43 and next is question 97. Paper.
But the question I am seeing, 85 number, in that English people have less explanation. It is about the American precedent. In fact, Kannada is better translated. They have given a word parliament. In the English thing, parliament word is missing. Page number 210, 85, question number 85. It can be reverse also, that's what I am saying.
Ultimately, you are
No, I'm just saying, you are saying we are agreed. No English person has come that your Kannada was better. Because see, ಇದರಲ್ಲಿ ಒಂದು extra ಪದ ಇದೆ ಸಂಸತ್ತಿನಿಂದ, ಇದರಲ್ಲಿ ಸಂಸತ್ತಿನಿಂದ ಇಲ್ಲ.
This is all your lordships have made out a case for me. Ultimately, the translation between English and Kannada is wrong. That is all that is sufficient for me.
But
Whether
I
it is in Kannada or in English. Yes.
Question number 85. Literally, what is the non-understanding? How it is different from an English translation?
Please allow me to say this. Let's forget my explanation. Your lordships have definitely seen that question and come to a conclusion that the translation is wrong.
We are not coming to any conclusion.
No,
We are only asking you. We are asking you.
Very good.
We are only asking. How can we come to conclusion?
Very
When
well.
your pleading is going on.
Please have a look at question. No, your lordship pointed out that there is some error. English has a worse off answer than Kannada. It is only people in Kannada before your lordship. The case is the translation is wrong. English to Kannada or Kannada to English.
Let us look at question number 85.
Yes.
In this, what the applicants could not understand, I like to know.
ಈ ಕೆಳಗಿನವುಗಳಲ್ಲಿ ಅಮೆರಿಕಾದ ರಾಷ್ಟ್ರಪತಿಯವರ ಇಟ್ ಇಸ್ ನಾಟ್ ರಾಷ್ಟ್ರಪತಿ. ಅಮೆರಿಕ ಐ ಡೋಂಟ್ ಥಿಂಕ್ ಹ್ಯಾಸ್ ಎ ರಾಷ್ಟ್ರಪತಿ. ರಾಷ್ಟ್ರಪತಿ ಇಸ್ ಎ ಗವರ್ನರ್. President. I'm sorry. Madam, it is Radhyaksha. Rashtraಧ್ಯksha. Kindly have a look at President of India. It has to be Rashtraध्यksha and not Rashtrapati. The question entirely is different now. Powers of the governor, powers of the president.
we will have to look at the dictionary.
Malad, therefore,
We are not getting.
your lordship, Malad, you have made out a case for me.
No, I wanted to ask you in this question, what was not understood?
Malad, kindly,
So,
question itself is
show us
wrong.
some questions, sir. I am only asking
This
you
85
to
question
show us
is
some
wrong.
questions which made the students feel that they are being discriminated from English to Kannada. Show us some question where they could not understand English was totally different and Kannada.
Kindly come to my compilation.
Where is it?
Yesterday, Mr. Rajgopal pointed out, and he pointed out question since your lordship, it was read it for your lordship consideration again. That since we are in a judicial setup, I just refer to that question itself. Question 97, second page. Second question, mother. Allah. Question 90, Allah, second page, Allah. Just first sheet, basic sheet. Next is question 40, next is 97. Just have a look. The following statement. The power of, I'm reading the English one. The power of judicial review in India is enjoyed by the Supreme Court as well as the High Court. Just have a look at the Kannada. ಈ ಮುಂದಿನ ಹೇಳಿಕೆಗಳನ್ನು ಪರಿಗಣಿಸಿ. ಭಾರತದಲ್ಲಿನ ಸ್ಥಾಯಿಕ ಪುನರಂ ಅವರ ಲೋಕನೆ ವಿಮರ್ಶೆ ಅಧಿಕಾರ.
ಫಸ್ಟ್ ಇದನ್ನೇ ಓದಿ, ಟ್ರಾನ್ಸ್ಲೇಟೆಡ್ ಓದಿ, ನೀವು ಕರೆಕ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಿರಲ್ಲ ಅದನ್ನು ಓದಿದ್ದಕ್ಕೆ ಆಮೇಲೆ ಇದಕ್ಕೆ ಬನ್ನಿ.
ಆಕ್ಚುಲ್ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಏನಿರಬೇಕಿತ್ತು, ಭಾರತ ನ್ಯಾಯಾಂಗ ವಿಮರ್ಶೆಯ ಅಧಿಕಾರವು ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಮತ್ತು ಉಚ್ಚ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಇದೆ. ಕನ್ಸಿಡರ್, is it correct or not? Now kindly see what is the translation that KPSC provides for a Kannada language student. ಭಾರತದಲ್ಲಿನ ಸ್ಥಾನಿಕ ಪುನರಂ ಅವರ ಲೋಕ ವಿಮರ್ಶೆಯ ಅಧಿಕಾರವು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಿಂದ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯವು ಹೊಂದಿದೆ.
See, Punaram, they have used the Punaram. Here they have used
ಅಲ್ಲ, ಅದು ಅರ್ಥನೇ ಇಲ್ಲ ಅದಕ್ಕೆ.
see, Punaram, see, you are using other word, vimarshe. They have used the other word, Punaram. That is a
ನ್ಯಾಯಾಲಯದೊಂದಿಗೆ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಹೊಂದಿದೆ ಅಂತ ತಪ್ಪಾಗ್ತದೆ.
ಈಗ ಸರಿಯಾಗಿ ಬೇಕಾದ ಪ್ರಶ್ನೆ who has done this? I will like to.
I am not saying, Malad, I am an expert is not what I am saying.
I am only asking you who has done this.
Yeah, this is what could have been possible.
Who has done this?
Applicants.
Applicants are expert in that.
No, I am only saying, Malad, that what is provided by them is incorrect. And if your lordships are sitting over and
We are
saying what,
just asking you
No,
to
but-
clarify. Please don't put back every time
I
you
am
say,
not-
oh, please don't use such things.
Malad,
Please
please bear with me.
See,
Malad.
when
Just
you
tolerate me
entire-
for 5 more minutes, I will complete my
in
submission.
your entire application, you are challenging the
ಈಗ
task.
ನಾವು ನೋಡಿದ್ರೆ ಪವರ್ ಆಫ್ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ ಈಸ್ ವಿತ್ ಆನರಬಲ್ ಹೈಕೋರ್ಟ್ ಆಫ್ ಕರ್ನಾಟಕ, ಆನರಬಲ್ ಹೈಕೋರ್ಟ್ ಅಂಡ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಅಷ್ಟೇ ಇದು ಮೀನಿಂಗ್. ಅದು ಇಲ್ಲಿ ಮೀನಿಂಗ್ ಬೋರ್ದಿಲ್ಲ. ನ್ಯಾಯಾಲಯದೊಂದಿಗೆ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಹೊಂದಿದೆ, ನ್ಯಾಯಾಲಯದೊಂದಿಗೆ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದೊಂದಿಗೆ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಹೊಂದಿದೆ ಅಂದ್ರೆ ಮೀನಿಂಗ್ ಅಲ್ಲ.
ಅಲ್ಲ, ಒಂದೇ my endeavor before your lordships is not to point out what could have been, what is.
ಜುಡಿಷಿಯಲ್ ನೋಟಿಸ್.
My
If you are coming,
ಜುಡಿಷಿಯಲ್ ನೋಟಿಸ್.
you have given us the list of the questions which you are thinking that they are translated poorly. This is the entire list.
Yes, that is the list of questions which are completely erroneous.
You can take judicial notice whether which is correct, which is not.
I'll come to that. I'll answer that question also. No, Malad, I am not here to point out what the translation should be or could have been. I'm only pointing out that the translation provided in the question paper is incorrect. It does not give the same meaning. That is the point that I am trying to drive home on. Right. I am expected to point out one other question, Malad. Just other compilation and question number 21.
Page
ನಾಲ್ಕನೇದು ಇರ್ಬೋದು, ಕಂಟು ಹಾಕಿದ್ರೆ ಅದರಲ್ಲಿ ನಾಲ್ಕನೇದು ಇರ್ಬೋದು. ಕ್ವೆಶ್ಚನ್ ನಂಬರ್ 21.
43 ಬಂದಿದೆ.
Question 21. 43
ಬಂದ
ಅದಾದ್ಮೇಲೆ 43 ಆದ್ಮೇಲೆ ಒಂದು ಪೇಜ್ ಫಾರ್ಮ್ ಕ್ಯಾನ್ಸಲ್ ಮೈ ಜಸ್ಟ್ ಪಾಯಿಂಟ್ ಇಟ್ ಔಟ್ ಅಲ್ಲೇ ಒಂದು ನಿಮಿಷ page 14 page number ಇದೆ
14 ಪೇಜ್ ಪೇಜ್
ಅದ್ರಲ್ಲಿ 14 okay
ಪೇಜ್
I'm only pointing out answer M. English alone. It aims to regulate import of any hazardous. I'm stressing on the word import. In Kannada, what is the actual translation on the left side? ಇದು so and so ಯಾವುದೇ ಅಪಾಯಕಾರಿ ವಿಷಯ so and so ತ್ಯಾಜ್ಯದ ರಫ್ತನ್ನು is export. In English it is import.
ತರಿಸ್ಕೊಳ್ಳೋದು ಆಮದು ಆಕೈತಿ
Export is ನಮಗೆ
ರಫ್ತು ಆಕೈತಿ
that the hazard today says
So how many questions were this way translated?
to us it is 79. Right, I possibly could have said entire question paper is wrong. I possibly could have said the entire question paper is wrong, but I am pointing out 79. Right, can I also say this much? While making this argument, Malak, I am aware that anybody can take a stand before your lordship that these are the questions in respect of which we have already awarded grace mark. And that liberty is available because in a statement nor by way of record have they pointed out to either the petitioner or to your lordship that these are the questions in respect of which grace marks are awarded. All that they say is these are the 5 questions. So very easy today before your lordship to say, in respect of this question we have given grace marks, therefore this question forget about it. This is the difficulty, Malad, in arguing without any record. That's Malad, the other question, Malad, that your lordship pointed out.
That is not going to the questions. Now we have understood that there were translation differences.
Yes. Now,
What is the
question is whether your lordships can take cognizance of it. Whether your lordships, Malad, can get into that question. Malad, there are umpteen number of judgments which are against me. And straight away considering there are umpteen number of judgments. And on the other hand, there are umpteen number of judgments where the Supreme Court and the High Courts have interfered and said, please interfere in these cases. Therefore, the criteria where a tribunal or a court or a judicial review is permitted insofar as question papers and key answer is, if the questions are blatantly erroneous. But I am not relying upon High Court judgment, I am relying upon the judgment, the Delhi High Court judgment, because it is a compendium of all other judgments.
Which one? The Gandhi case?
Om Prakash Verma. But I'm not, it's not that Delhi High Court judgment is binding on your lordship. Definitely your lordship can take assistance of it, but the stress is more on since all the judgments and the relevant paragraphs were in one place, I'm pointing to it. Paragraph 1. How far can a court tinker with the answer key provided by the authority which conducts an examination? Is there a complete proscription, or is the court only required to be cautiously circumspect? This case throws up this issue on which the law appears to be settled in sharply. Now, the first judgment is Kanpur. There is no case, Malad, on key answer in judicial review insofar as key answer which is decided without reference to Kanpur. And ultimately, Malad, what court says is, if your lordship should, even in this case, they interfere, they would examine internal paragraph number, internal text 34 or 44. That it would start, may I just summarize the takeaway at internal page 31. after my lord, a summation of all the judgments are 72. Rahul Singh therefore again advocates the circumspect approach. The takeaway, the following takeaway emerges. Circumspection is generally with the general rule, especially where experts are considered the object raised to the key answer. It is, however, equally the rule that there is no proscription against courts examining the challenge to the key answer, even where experts are opined. The law does not comment or even recommend a hands-off approach in an appropriate case. The court can even examine for itself the correctness of the key answer under challenge, in which the process the court is also empowered to refer to authoritative textbooks on the subject, especially those which form a part of the student's curriculum. Where the question is simple and not admitting of any complexity and can command only one answer which is apparent to the court is not proscribed from taking a view based on its own perception of the question. To take an extreme example, the sum of 2 and 2. That, however, would have to be in a rare case in which the answer is so apparent that there can be no doubt about it, and not one where the opinion of someone with greater expertise would help for where there is ambiguity. In any case, the guiding principle is that general rule against accepting the suggested key answer stands relaxed only where the suggested key answer is proved to be wrong, not by an inference process of reasoning or rationalization, but clearly and demonstrably wrong. Therefore, my submission to your lordships is, it is not a case where your lordships are completely debarred from examining the question in itself. If I am able to demonstrate, not by a process of deduction or rationalization, and blatantly, on the face of it, if it's erroneous, I am entitled to proceed before your lordship.
That's one thing, because we are also, and all other cases also. The problem is about the key answers. Most of the cases are about the key answers were defective. Now, because of the wrong translation, I asked this question earlier also. Because of the wrong translation of the, wrong translation or whatever they could not understand, was there any problem in the key answer as such?
Yes.
Was the key answers also different in Hindi, in Kannada and English?
The two questions that I pointed out, key answer was only wrong. The two questions that I pointed out, judicial review and import and export, those are the answers. The answer itself was wrong. If there is any, I'm just giving an example.
What are the question number that is 21?
Question number 81 and
97 and 21.
Which both here is 20.
Okay.
Okay, question number 21.
97 and 20.
Right. And now, one thing that your lordship should consider on how it has to be translated is all on one side. There is another aspect to this. Should the question paper first be set in Kannada or in English? Right? And if there is ambiguity between the two, which will prevail? Right? In Rangarajan, there is English. That is doubted perhaps by a Madhya Pradesh judgment, which is now pending in SLP. In SLP number 17436 of 2018. SLP civil number 17436 of 2018. When it was admitted, Malad, the question was framed after reference to the earlier judgment of the Bombay High Court in Haji Mohammed and the later judgment of the Supreme Court in Leather. They said that we refer it to a larger judgment that is pending consideration. Now, I am not saying this authoritatively, but if your lordships want, can I draw support from the Constitution? There is one provision of the Constitution which may help me. Now, after the state of Karnataka was formed, there are two enactments in Karnataka, which is the Karnataka Official Languages Act 1963, where Kannada is recognized as the first official language. Now, Malad, this is where Article 348, subclause 3 of the Constitution steps in. I'm not saying, Malad, it steps in insofar as the question paper is concerned, but let me just read this. Notwithstanding anything in subclause B of clause 1, where legislature of a state has prescribed any language other than English language for use of bills introduced in or acts passed by the legislature or the state or ordinance of the state or rule, regulation, bylaw referred to in paragraph of that subclause, a translation of the same in English language published under the authority of the governor of the state in the official gazette shall be deemed to be an authoritative text. Therefore, Malad, it is the language, English language translation which is the authoritative text. But the official and the authority still remains in the original vernacular languages after Malad, the Official Languages Act in 1963 has come into force. It applies insofar as acts and enactments. I am aware of that. But here, where Malad, students who are studied in Kannada medium and from the most backward regions are attempting to get into the civil services, Malad, they can't possibly be ousted. Like I said, it is not an adversarial litigation before your office. I am not trying to win against KPSC or against state, neither are they. The ultimate aim is, has every student had a reasonable and a fair opportunity to succeed in this examination or not? And the answer in my respectful submission is an absolute no. Well, can you consider this? It's not a very emotional argument.
Apart from this application,
Yes.
are there any other applications somewhere in any one of the tribunal or high court on the same issue?
On APSC exams,
Not on this.
on this issue,
But
not
these
other.
people are not from such backward places. They are from Ramnagar, Chitradurga, Tumkur, Mysore,
ಅಲ್ಲ ರಾಮನಗರ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅದ್ರಲ್ಲಿ ಯಾವ ಊರು ಅಂತ ನೋಡಿ.
Balaji, Nelia, which is all in the Bangalore also. I just wanted, you said that they are from very, very
No, Malad,
backward area.
your lordships are not seeing a case.
We are
Your
not,
lordships
I'm
are
just
seeing a
asking
case.
for my own
Yes,
information.
that's what
Whether there is any other application pending on this,
I don't, not to my knowledge.
apart from this.
Yes, Malad, and your lordships are examining a cause and not just the case. Right?
Take case. In case of APSC is a respondent, the principal bench only having jurisdiction. That's what. You can find it. You have to file here only.
APSC like that.
You have to file here only. Apart from these three.
That's the argument simply last and concluding submission is this. ಸರ್ಕಾರಿ ನೌಕರಕ್ಕೆ ಕರ್ನಾಟಕ ಲೋಕಸೇವಾ ಆಯೋಗ ಮಾಡೋ ಎಕ್ಸಾಮ್ ಅಲ್ಲೇ ಕನ್ನಡ ಭಾಷೆ ಪ್ರಶ್ನೆ ಸರಿ ಇಲ್ಲ ಅಂದ್ರೆ ಇದಕ್ಕಿಂತ ಯಾವುದು ವಿಪರ್ಯಾಸ ಇರಲ್ಲ. That is all my submission. If in Karnataka, if Kannada language exam, if Kannada question is not correct, what more minutes could be asked for before your lordship? That's my submission.
On the state, one because
He's there. He's there.
first. So we wanted to make some submission to Manu Prakash. Bhanu Prakash, Bhanu Prakash has not filed any reply statement. We told you whether he is want to submit any some notes. Yes, notes. State down. Bhanu Prakash. Yes, notes. Notes. Not filed any reply statement. Do you want to submit orally?
Yes, my lords, because there is no prayer sought against the government as such, my lords. It is only as against the second respondent the entire sought for. Only clarification as to whether the government had a role in the cancellation and this thing I need to answer, my lords. If my learned friend Mr. Rubin Jacob finishes it, then I can answer any of the queries if at all are there.
When you are
I'll remind for 10 minutes.
what?
And then I'll do it for the month because for the month. I'll be starting on the district professional. Passing on the district professional schools. Because there is a separate rules that is not framed for the purpose of recruitment laws of gazetted professionals. This is called not the Karnataka Recruitment of Gazetted Professionals, appointment of competitive examination rules 1987. Now, let's look at this rule 4. Rule 3 mechanisms first. The provisions of these rules shall apply in respect of direct recruitment. Rule 3 members. The provisions of these rules shall apply in respect of direct recruitment of Group A and Group B posts in the state citizen specified in column 3 of Schedule 1. Relating the services specified in the recruitment entries in column 2 or thereof. Then members B and other things are not talk about amendment. Now, can you see 4 examination? In combined competitive examination, for recruitment to one or more services or groups or posts mentioned in Schedule 1 shall be held every year. Supplementation of division of any subject or syllabus of the subject. The commission shall invite applications in the prescribed form for the competitive examination from the intended applicants. The candidates of the competitive examination shall clearly indicate in the application form the service or post for which they wish to be considered for appointment in order of preference. They should not be considered for such a service or posts which are not preferred by them. Now, can you see 7 plus academic qualification and physical standards? No candidate shall be eligible. Under 7 plus. No candidate shall be eligible for recruitment under these rules unless he possesses bachelor's degree or master's degree awarded by University of Law in India or possessing equivalent qualifications. So the minimum qualification not to hold this from this bachelor's degree. My lord's not candidate on it. So now kindly see what's the schedule, which is at page 7. And you must know one thing. Schedule 1, we have given the gazetted professional students exam, the services not included is provided for. Can you see notes the nature of service? It's all the Group A and Group B post notes in different departments. Notes have Schedule 1 is Schedule 1. Group A notes and Group B includes the Karnataka Administrative Services case junior scale. So notes in respect of the top post, top civil services post that could be filled up by direct recruitment. This is the examination that should be conducted. Now, why I'm putting it out is to just make out a case with regard to the standard to which the candidate is going to be held and the standard is required to process. Now, I'll also respond and at the end, an authoritative statement was sought to be made with regard to the thing. I'll come to that. Now, kindly see Schedule B. Schedule B is the scheme of examination. Page number 9, internal page 9. If my notes have it. This is important notes because we are here. We are at this stage now. Schedule 2. Section 1, the scheme of examination. The competitive examination will comprise of 2 stages. A. Preliminary examination, objective type, for selection of candidates for the main examination. Can you note this? It's for selection of candidates for the main examination. B. Main examination, written examination and personality tests for selection for candidates for various services and posts. One here was preliminary examination is nothing but an elimination examination to be eligible for a main examination. Now, can you see notes 1? Under section 1, for the submitting
a preliminary examination, preliminary examination. The preliminary examination shall consist of two papers or objective type within bracket multiple choice. One, each paper carrying 100 questions, with each question carrying 2 marks. Each paper shall be of a maximum of 200 marks and of a duration of 2 hours. Total of 2 papers, 400 marks in the following description. Namely, now kindly see notes, paper 1 is general studies related to national and international importance, humanities. Number of questions and marks are also given. Now kindly see notes, the note, which is very important below it. The question paper shall be set both in Kannada and English. The question paper is set both in Kannada and English. So source to translation to target to it is not. It is set both in Kannada and English. The standard, the standard of general mental ability questions of preliminary examination aptitude test shall be that of, can you note this one, 10th SSLC and the remaining papers are that of degree level. This is not pertaining to general mental ability, that is only in respect of paper 2, serial number 3 below, which are degree level questions. Totally across paper 1 only, we have 2 serial numbers, paper 2 is 3 serial numbers. Serial number 3 is general mental ability. General mental ability is 10 standard level game. Mikidella, general studies, humanities, general studies, and other things are degree level. Can you know this? Now, see mechanically similar. The number of candidates to be admitted to the main examination shall be 20 times. So this has been amended. Latest it is now it is 20 or 15 modules. There is a substitution. Not the kind of note that one. This was available in the website. 20 or 15 modules. For this exam it is 15. 15 times the vacancy notified for recruitment in the order of merit on the basis of performance in the preliminary examination, subject to accommodating the same ratio, the adequate number of candidates belong to categories of scheduled caste, scheduled tribes, each of the other backward classes and others. And you know, there shall be negative marking for incorrect answers for all questions, except some of the questions where the negative marking shall be input in the form of different marks being adopted to the most appropriate, not so appropriate answer for each question CND. There are 4 alternative questions to each, alternative answers to each question. For each question of which a wrong answer has been given by the candidate, 1/4 of the marks assigned to that questions shall be deducted as penalty. If a candidate gives more than one answer to a question, it shall be treated as a wrong answer, even if one of the given answers happen to be correct, and there shall be penalty, same penalty in accordance with clause 1. If a question is left blank, that is no answer is given by the candidate, there shall be no penalty for that question. Thereafter, it is about the syllabus. Syllabus is provided for, and after that, the main examination goes. So we are not only at this stage. Notes kind of note. In the my notes have already noted. We have passed on notes which is already supplied to all of them. The provisional key answers notes were published on 15/1/2025, and then the notes revised key answers notes were published on 30/1/2025, and notes the final revised key answers were published on 3/2/2025. So this notes I have the passed on notes on revised key answers.
There is no any institute pertaining to the publication of the provisional key answer and final.
No, I am coming to that. Why?
Only whether they can call for the objection from the candidates pertaining to this.
Then after the year notes across board. Objections are called for from candidates. Not it is like this. Now in an MCQ paper, the MCQ or OMR sheet or one highly important. On the basis of the key answers, your final key answers, you are able to know your score. You know your score. But this is not an absolute merit case. It is a question of relative merit. So that is 1:15. So you have to score better. In case 100 posts are there, 1:15 notes will be 1,500. So 1,500 candidates notes will be eligible for the main examination. So you have to your score should be within the top 1:15 ratio. So when the final key answers were, I am coming, I am pointing out those dates only for this purpose. 2 of the petitions, except the first petition, the remaining 2 petitions for us were filed only for us after we had published for us the final revised key answers. The first petition was filed on The first petition was filed on 27/1/23/25, which was earlier. But the other two petitions, notes, one is 10/2. In the other case, notes, it is subsequent, they have not put the date in the copy that is given there. So, my submission notes is this, that when we publish the revised key answers, in respect of the other two petitions,
when you have published a revised key answer.
as on the date, notes, they filed, as on the date, the connected to applications were filed, the revised key answers were available to them. But in their prayer, conspicuously, now my learned friend is saying the process is slightly opaque, I don't have the records and other things. But in their prayer notes, all they have done is re-examination. All they want is the re-examination. Now, notes, there could be multiple solutions based on notes in case. It all depends on what is the examination that we are conducting. So therefore, in most of the cases, there could be a case for re-examination. I'm just putting it out. There could be a case notes where the grace marks is given, but it should be given in a particular manner, attempted questions for the go, attempted manner of questions for the go. There could be multiple solutions notes based on a particular factual matrix. But notes in this case, I will endeavor or I will not demonstrate that the course of action that has been finally adopted by KPSC to give grace marks to particular questions and to give it to all of them is the correct course of action. Because if I do anything else, I'll be able to justify how it will prejudice the other person's case. And it will not yield to the benefit of the applicants also. So I will not be able to demonstrate that. You can continue there. But that is actually restricted already. Why can't
So heard the arguments of the learned.
But your date of
Council.
taking final application was only 30.
Learned Council for the applicants in application number 6862689 of 2020. The learned Sri Jacob, Senior Counsel for the KPSC, in part, and the learned Sri Jacob, learned Senior Counsel seeks time for further arguments for KPSC. Hence, time is granted till Thursday or 13. 13/3.
See, the lot of the age is here.
Banu Prakash learned PhD appeared for respondent number 1 who heard the learned PhD appeal for R1 and heard the learned Sri Jacob Hinkapur. Senior Counsel for KPSC in part and change my and for further arguments, Kalan.
Interim order,
Need to take application, not to.
only in one case there was an interim. Indeed, to total.
It's all.
We have some.
Interim order, interim direction, interim direction in all cases.
Direction.
So far as conducting so
Number 30.
Yes, conduct no representatives made for the applicant and for hearing 25 on the isn't date possibility.
Therefore,
Sorry. I will start further arguments, sir.
Bill number 25, Raghavendra Singh, I believe,
Additional inspector, but getting
Sir, additional 10%.
Yes, I've got the instructions and they are already processing. One of the thing is they wanted to obtain a willingness from the common candidates.
Sure.
And then do it.
One time.
Still, until 2 months time or 3 months time for.
ಅವ್ರು additional list prepare ಮಾಡಿ ನಮಗೆ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ ಅವ್ರು ಕ್ಲಿಯರ್ ಆಗೋದು.
Memo has the direction to release the additional select list within 2 months. May not make kindly there is order 6 to 2025.
ಒಂದೇ ನಿಮಿಷ.
You have
More say.
Okay, already given 1 and 2.
See, but still the people are coming for the, you had 89 posts.
Yes.
Only 60 have been filled up.
Yes.
Now, that means that this additional will be 10% of the vacancies.
Now there are 58% that have been overlapped.
But there are so many
Because
court
there
cases also.
are
There are so many court
two
cases.
lists are there. So in both the lists, so there are common candidates are there. So we are going to get the options for them and thereafter we will release them.
It means we have heard it.
yes,
Prayer number 1 and 2 you are not pressing.
Yes.
it's to order. It's to order 6 months can be. We see present. They already prepared additional list, additional select list and to be prepared after seeking the
We need to do that.
We have